think? I think we should start.
I think we should start too.
Okay. So I will say a few words of introduction, and then without further ado, we'll put it to you. So good morning, everybody. Thank you for joining us today on a snowy April day for a presentation on professional wills and professional plans. The reason we wanted to do this is, of course, difficult time in our country right now, and people are being very thoughtful about what will happen to their practices if they're no longer able to work, whether temporarily or permanently, whether through disability or death. And unfortunately, there have been cases in town very recently when therapists passed away. I lost a very, very good colleague a couple of years back, about a year back, and it was really devastating to his patients, to his colleagues, to his family. So I asked my husband, Aaron, to talk a little bit about what these professional plans may look like. He is an attorney specializing in estate planning, and although professional estates is a different beast, he agreed to help us out with this. So, drum roll.
Thanks so much, Aaron.
Oh, of course. My name's Aaron Kendall. I do estate planning and business law. So Natasha asked me to take a look at this and to go ahead and put something together for you. So let me go ahead and share the presentation for a sec here. All right. First of all, what's the main issue for therapists? The biggest problem you've got is you do have an ethical obligation to ensure continuity of care for your clients, whether you're absent, you're disabled, or you're dead. It's not a statutory requirement. There's no law in Michigan that says you have to, but everybody has an ethical requirement to do it, which means you can lose your license and be grieved for it and all the rest, and it's not a good thing to disappear on your clients. We've had issues, not just with therapists, but even attorneys that have disappeared at times and abandoned their clients, and very bad things happen, and we don't want that to occur. Secondary issue, you probably want to get some of the value of your practice to go to your beneficiaries rather than disappear. Most therapists in practice run as sole proprietorships or partnerships. They're not incorporated, and there's some issues with that as well in terms of how do you wrap up that business. Just put together some of the ethical directives for people so you can always look up what you're supposed to do under your own license. Straightforward stuff. Biggest issue, like I said, is continuity of care. And a lot of people are talking about professional wills. Little problem is there's no legal requirement that your professional will has to be honored in Michigan. It's not a will the way we define wills in Michigan. Instead, it's basically a tool to let you have instructions to people to what should happen if you're disabled, disappeared, or deceased. So it's not necessarily a binding legal document. It's more of a how-to guide or a continuity guide for your practice. Okay. Also, what should be in your will? Professional will. We'll just call it a professional will for now. One, let people know where things are and what needs to be done. You know, it's who, what, where the heck are your keys, your contacts, and your passwords. Generally, it's a good idea if you're a sole practitioner, have a relationship with another therapist, let them know what's going on in your practice, and have an agreement that says if something happens to you, they can step in and at least arrange to transfer your patients to other people or to take them on themselves. Well, the focus here is to make sure that your patients still receive care no matter what happens to you. Some good things. One, have a template for communicating to your patients for your successor to use. You know, a nice letter to them saying whatever's happened, and this person will be taking over, will helping to coordinate your care for you. Also, just having it signed, witnessed, notarized. And also, what's been left out in a lot of form wills, have the successor therapist actually sign that agreement to say that they will take responsibility. And most form wills leave that out. So what I'm going to do is we will pop up a, let's see if I can get back in here. There we go. I'm going to put in a sample agreement. Also, if you have questions and stuff, there's a little raise your hand thing, and there's a chat box there as well. So you can ask questions as we go here.
On the bottom left of the screen, there's a hand if you want to ask a question, and there is a, yep, there's Stephanie wanting to say something.
Yep.
Go ahead, Stephanie.
You got that?
There, I'm unmuted. Okay, so just real quickly, does the person that you give responsibility to have to have some kind of HIPAA arrangement as far as like having, you know, your patient's names? Like I work by myself, I don't have a co-therapist. Like who would I give that responsibility to that has the ability to have confidentiality and all that?
I'd definitely recommend it being another licensed therapist.
Yeah, it has to be.
You don't want to be just anyone.
Okay.
Because they will be dealing with this confidential information.
Okay.
That's kind of spelled out in most of the professional wills, but you don't just want anyone digging through that stuff without having some kind of a professional license to protect that.
What about an attorney, Aaron? Can an attorney be your representative?
Can be potentially. I mean, attorneys do have attorney-client privilege, so it can be privileged information. I believe we can deal with that stuff. I know attorneys regularly do look through medical records, and we have all sorts of fun confidentiality things.
So
I imagine it won't be very much different than, let's say, somebody sues me, a patient sues me, and you help me defend myself in a lawsuit. You know, you are looking at confidential materials, so I imagine it won't be much different than that.
Yeah, there's that, but you may want to, instead of you may have an attorney involved, but it may make most sense to have another therapist involved so you can immediately transfer care. And because when attorneys aren't therapists, we don't know what you know about patient care or what people's needs are or what this note happens to me. We can figure it out that says, you know, patient is suicidal. We may clue into that. We likely will not clue into a lot of other notes that you make or things that are important to therapists. So it's best to have another therapist on tap to deal with this.
This is Nina. I had a question in reference to, is it important to put who that person is in my informed consent that I give to clients at the beginning of our process? Would that be helpful as far as HIPAA compliancy and things of that nature, to say this is the person in case something happens to me that will be contacting you?
Wouldn't be a bad idea. Of course, that can change over time. You can also do it on the back end by having the patient sign some releases at that point to transfer information. But probably having some kind of informed consent saying, I do have a backup therapist in case something happens to me. That person is this, and they'll contact you if something ever happens. Not a bad idea at all.
I believe that's part of the template, actually. I think Rachel is raising her hand.
Yep. Go ahead. Oh, I think you're on mute. Okay, there's a little mute button on the middle left little picture of a microphone. Oh, almost got it. Went off for a sec, went back on.
If you're having a hard time getting the microphone to work, you can also type your comment. On the bottom left of the screen, there's a little dialog box. And you can kind of put in your comment by typing it in.
I mute myself, then it automatically seems to mute me. So I think I'm unmuted right now, so I better
we can hear you.
Hurry up and say it. So my question is about the charts and the information. Like, is there a legal obligation of how long do we need to either keep the chart for a client or make sure that the chart is transferred someplace where it's findable for a client? Is there a certain amount of years that works for? I mean, I know in the medical field it's at least 7 years, sometimes forever. I don't know whether there's an answer to that.
Off the top of my head, I can't tell you the exact answer to that, and it may vary among different therapists' licensing requirements.
That's okay, Erin. We know the answer to that one.
Okay, go ahead.
Ginger, go ahead.
It's 7 years for LMSWs. It's 7 years.
Okay,
It's
thank
7
you.
years as well
But-
for LMFTs, but it has to be either 7 years from the last appointment or
Mhm.
7 years from the age of 18. If you work with a child, it is 7 years from them turning 18. So potentially it could be 17 years if you're working with an infant. And I would probably keep kid stuff even longer, to be honest with you. I've never destroyed a file yet, and I've been in practice for a long time.
So the question is, what happens in the context of a professional will? Is it kind of like you have to make sure that you will the charts to somebody, even if you don't
Yes.
sell the practice?
Right.
Yes. I think Erin will get to that. That's typically in the, for at least for therapists, that's part of the template for what you need to have in there, because there needs to be a way for your successor to be able to access that information on either your electronic medical record, or if you have paper charts, they need to be able to get that information.
Thank you.
All right, so we're going to take a quick look at a sample will. Let me just sample personal will here. Let me see if I can pull it up. All right. There we go. Hopefully you can see that.
Yeah.
This is one that's kind of a popular template online, but I've altered it a lot to make it more compliant with Michigan and make it work better. So the idea is, again, the problem is this isn't necessarily an effective legal document. This is more of a continuation of care document to let you dictate to other people what you want done with your stuff and let people know where your things are. If that makes sense, hopefully. So, for example, we want to have, this being just your one directive. So it gets rid of any prior ones. I don't know if you can see that highlight there. Put your license number in place so people know things. The next one is you want to identify who are your backup therapists. Typically, I suggest at least two different therapists have a backup therapist, and also have a secondary. Because in case your backup therapist is out of town or has decided not to do things for you or whatever else, makes sense to have a backup. Okay. Next part is, in addition to the backup therapist, you want someone to be what I call your designee. Typically, this is a family member or somebody that knows you very well, who is able to communicate to the backup therapist, hey, this person has now disappeared or has died or is disabled and can't treat patients for X amount of time, so that they can let the backup therapist or secondary therapist know. And that can be anybody. Obviously, should be somebody you trust and that knows you very well and is in regular contact with you. Doesn't have to have a designee. If your therapists know you well and know that for example, that you just died, they can immediately still take over. They don't need a designee to do that. Okay. So the designee can notify people and try to do things. If the designee say can't find the backup therapist, then they should try the secondary therapist. Okay. Next part is where things start to get complicated. Part of the problem is obviously you have confidentiality with your patients. You have your own confidential records, your own financial records, everything else. My suggestion for these wills is after you discuss them with your backup therapists, that you seal them in an envelope and give it to them in a sealed envelope, because this is a lot of information you don't necessarily want to have just floating out there. And you don't necessarily want to have the backup therapist having access to your stuff until it's necessary, but this will give them that access. I've added a piece on digital assets. There's a lot of issues now with the fact that we do so many things online. A lot of companies, if you don't have your list of passwords, which I highly recommend having a list of passwords somewhere that your backup therapist can get to, don't have it pasted on your computer on a post-it note. That won't help. And hopefully you have a better password than 1234. But typically, if people can't find your password to something, this power regarding digital assets should let them contact that service provider and get access to that account. And that wasn't in the original professional will sample. I added that, and it should work. It has not been fully tested in court, but this is as close as we can get to making sure that you'll be able to get in if somebody can't recover your password.
Can you please give examples of what you're talking about here? Like what, Facebook accounts, email accounts?
Facebook, Gmail, say you have an online practice account billing system, and go from there. Those need to be recovered. Gmail and Facebook both have their own internal methods that you can designate someone, but if you fail to do that, you can still get in sending them a copy of this power and this backup will.
So within Gmail and Facebook, I can actually designate people who can look at my account after I'm gone.
Yeah, there are some spots to do that.
That's kind of cool.
Yeah, but a lot of places do not have that. A lot of services don't have that. So the idea is that this should let you get in, and this is as close as we've got that matches a lot of law that we already have on the books about accessing people's digital information. Yeah. Right, and I think Nicole asked a question that the designee is really someone close to you who can let them know that the backup therapist needs to step in, and that's correct. The idea is your backup therapist doesn't necessarily have to be in contact with you all the time. You may just be going out for coffee on occasions or whatever else. But your designee is someone you know and trust and that knows you. Most time, typically, it's your family, your spouse, your best friend, somebody that knows you and will actually know if something happened to you, and hopefully sooner rather than later. And then they can tell the backup therapist what to do. And okay, hang on. We're back to there. Do that. All right. The rest of it goes into information regarding where your records are. A lot of people now are doing them computer-based records, but if you have paper records, where do you keep them? The idea here is to prevent your backup therapist from having to scramble and look high and low, trying to find where you put your stuff. You use, what do you use for billing? What's your username and password for it? Where's your actual office? Do you use a computer? What does it look like? How do you get into that computer? What's your phone number and voicemail? You may need to change a voicemail message saying, please contact the backup therapist. Professional email, what your email address would be. Do you have a website for your practice? Again, marketing, a lot of this stuff is pretty straightforward. This is a lot of information, just basically to let the next person know where they can find everything. Again, where's your client list? Do you have a client list? Are you employed by a service? You may want to let them know that you're no longer able to see clients. They're going to wonder why you haven't been turning up to work. Are you supervising somebody? And the important part, continuity of care. Again, you want to let them know the backup therapist is going to contact them, say, hi, I'm the backup therapist for this person. Going over the records, see this is the case. Would you like to come in and talk to me? Or may have to work with other people or whatever else they prefer. Okay. Or there may be people you don't want to deal with. Even if you're the backup therapist, you don't have to take those clients. But you do, as the backup therapist, have an obligation to at least try to refer them to someone that can help them. You don't have to take on everybody, and you may not be able to. You may have a full boat yourself, but by signing up as a backup therapist, you're agreeing you're at least going to try to refer them out and make sure they're covered. Financial arrangements, again, money matters. You want to check client balances and things of that sort, and figure out payment and all the rest. Maybe outstanding bills in your practice that need to be done, all the rest. And the backup therapist is given the rights to inform them about things. Various other things about contacting, if you've got an office lease, letting the landlord know that you're no longer going to need the office. Liability insurance, letting them know that somebody's deceased or disabled is important, because that can set some time limits for claims. Letting your state licensing board know that you're no longer practicing is, again, also helpful. Again, you're giving the backup therapist right to see all your records, which is also important. Are there accounts you need to have closed, financial accounts you should have closed if you're no longer operating? Are there still things that should still be paid as long as things are going on? A lot of those are questions that depend on how you're running your practice and what you're doing. So again, forms are not necessarily bad, but they don't fit everybody's situation. So it depends.
I have a question about that. Can we pause here for a second?
Sure.
So if I have a business account, which of course I do, and it's an S Corp account, how are you getting into that? After
And the
I'm
bank
gone.
account itself. Nice thing will be it's an online account, right? So you'll have access to the online passwords and such. But if you're dead, it likely will freeze at that point, and you will have an interplay between your actual personal representative and the therapist for the business. Again, these professional wills aren't part of probate. They're not really part of the legal process when you die. This is more of an instruction booklet that says, what the heck do you do with my practice?
So in addition to this document, I have something in my personal document that is fully legal.
You do.
That will designate people to go into my business account and do whatever needs to be done. Empty it, I suppose. Empty it and close it.
Right.
Okay.
Yep,
Thank you.
So yeah, definitely. So yeah, this is only a piece. This does not cover you sufficiently for your personal assets, for things you want to have happen if you die. That this isn't covering any of that. This is basically a guidebook to whoever's picking up the pieces, because you've now planned ahead at least and said, okay, we want this to happen. Okay, a couple fun questions here. So for what happens to your office lease if you pass away? Answer is it depends. One, if you're not incorporated, it's just personal to you. At most, the landlord has a claim against your estate for the remainder of the lease, which is, however, matched off against his or her duty to mitigate it by getting another person into that spot. So technically, your estate may be responsible for the rest of the lease, but they have to try to re-rent it. And a lot of landlords will go, okay, you're dead. We're just going to terminate the lease at that point. There may be a termination on death clause in your lease that closes it out that way. Things of that sort. So it depends. If you're a corporation or such, typically it is still it's a issue with the corporation. If there's successors that you have for your corporation or your LLC, they would still be responsible for the lease as the LLC. But again, if there's nobody there paying it or anything else, it can go from there. Hopefully that's clear as mud anyways. There's various circumstances that can apply with leases. You have to look at the lease, see what it says. But typically what will happen, it is a potential claim against your estate. Whether landlords are going to bother is hard to say. Can you put your LLCs into your trust? You can put the ownership portion of the LLC into a trust. You can have your trust own the LLC, which again, legally, you don't really put the LLC into the trust. You put the ownership interest in the LLC into the trust. That can be done. You can move those in that way to have it go there, or you can have again, depending on how you have your LLC set up, you can sometimes have the proceeds of it pay it in or whatever else. There's a lot of fun, complicated things, but you typically can do it in a way so that it goes into your trust and then gets distributed from there. There's sometimes that you don't want to do that. So hopefully that, again, depends on your situation, depends on what's going on. All right. Yeah, relief, again, this is saying to somebody, the relief portion, okay, if you're the backup therapist, you know what, you can go to the secondary therapist for help. You guys can also utilize other therapists and experts to assist with it. Generally, you're going to want client consent before you start bringing in other therapists or things like that. That's pretty normal behavior for that. Backup therapists do get compensated for this. They're not expected to work for free. Typically, again, as with anything, open communication between you and your backups is important. You may want to discuss, not only that they're willing to do it, but you may want to discuss what's a reasonable fee for them to be handling these matters for you. So it can definitely, again, it depends. Can be discussed on their hourly rate. It can be discussed that, well, for dealing with patients, they should definitely get their hourly rate. Or it could be that they're going to agree that whatever you were billing the patient for is the same fee they'll accept, maybe higher, maybe lower. You're probably going to want to discuss a rate for all the administrative work that they're going to have to do on your behalf for this. And again, document it, write it down, have people agree ahead of time so there aren't hard feelings later and there aren't issues that arise. General legal rule, I'm sure you've heard this before. If it's not written, it does not exist. Basically, with any of these agreements, you want to have it written down. You want to have it documented. You want people to be able to know what's happening. Okay. You can change this. Again, this is not written in stone. It's essentially a continuity of care document. Your life changes, your needs change, your clients' needs change. You may go to a totally different system or method. Goes from there. You want to let people know where the copies of this professional will are so that they can find it. The worst thing is if you have a complete estate plan that's hidden somewhere and nobody knows where it is. Locking your estate plan inside a safety deposit box is a very bad idea because nobody can get into that safety deposit box without a court order because the plan that appoints them is stuck inside the safety deposit box. Becomes a wonderful circular problem there, which is bad. So I strongly advise against putting this in a safety deposit box. And again, just rights, giving your backup therapist full rights. And I say again, all digital access rights. Again, it's repetitive, but I'm doing it on purpose to be repetitive, just to try to stress to various digital companies that you have these rights to carry out everything the backup therapist has to do to make this thing work. Then I add in, have it signed and witnessed, have it notarized in front of a notary, and also have your backup therapist agree and sign it and have their name and number there so that somebody can contact them easily. Again, we're not trying to make it scary for the backup therapist. We're saying they have to act in accordance with the standard of care applicable to therapists, which you're already doing, so you don't have a problem. Reasonable steps to follow these instructions and maintain records of what you're doing as a backup therapist. Whether it's disability or they're absent or whatever else, you need to keep records because you're acting in what's called a fiduciary capacity at that point. You're acting on behalf of the person who made this will and you're following their wishes. So you do have some duties to them. So you do need to keep good records of what you're doing. It goes from there. All right, Natasha, where is this money coming from? What money are we talking about?
You said that the your designee will get compensated. Not your designee, that's a family member. Your secondary therapist, how are they getting compensated? From where, practically speaking?
Hopefully your practice has some funds in the account so they can pay for this. You may, again, you may need to, hopefully there's something in those accounts. You likely do have some funds coming in from patients or such. Most likely the practice would be paying for this and transferring the responsibility for the practice.
Got it. Okay.
If you have a practice that doesn't tend to keep money around at all inside the practice, you may want to, again, have it sketched out ahead of time saying, okay, we need to do this. And it'll come out of my estate, or then again, we're going to need some other documents interrelated with this, like your will or your trust that says, yes, the backup therapist gets paid for this. Because quite frankly, for a backup therapist, this is going to be a lot of work. They do deserve to get compensated for this. And it's the same idea that you want, that if you're doing it on somebody else's behalf or somebody is doing it on your behalf, they should be compensated for what they're doing. It also makes them a lot happier and a lot more willing to do it, which is always a good thing. Tend to want them happy. Right. So that's that document. That's a sample. And I will back in. We'll go back here again.
Can I ask a question?
Sure.
Can we get a copy of that, or?
Sure. Yeah, we can definitely do that.
So after this is completed and recording is complete, we will email both the recording and the sample document to the same email that you have been getting emails from us.
Great.
Whatever address we have on file, you'll have a recording, and you will have this template as well.
Thank you.
We'll at least email a link to the recording. Emailing the video would be huge.
Okay.
So we will have it stored in a way so that you can see it. Okay.
Hi, can I ask you a question, please?
Sure.
So let's say, is there any disadvantage of just getting a disadvantage in getting a non-therapist designate for this? I'm thinking like, with most of us, I think we have all kind of different clients, and there's not necessarily one therapist that would be better for them, but rather if we made up a list of possible therapists for the designate to give the clients as an option, is this a possibility? Is there something wrong with that, or is there something not smart about that?
I'd probably still advise having a therapist as the person managing this, because again, there is confidentiality. Therapists are trained in dealing with clients. They can understand what your notes mean a lot better than a layperson. If you give me a list of people with your client A, B, C, and D, and you say one of them has bipolar disorder, the other one has generalized anxiety not otherwise specified, and the other one has something else, I'm going to have no clue who is best for that. Your other therapists probably know via networking with other therapists who is good to deal with those problems. It just makes a lot more sense to have a therapist who actually knows what is going on act as the person to decide what's going to happen with those clients.
I think I have a suggestion for what Rachel is talking about. You can have a person who is your, distributor, if you will, who goes into all the passwords and all of that stuff. But you can also have a list of referrals, right? You can have a list of professionals in the community who.
Right, that's what I'm talking about.
Right, but that's not necessarily what Aaron's talking about. He's more talking about who's going to the bank account and who's going to the electronic medical records, who is, talking to your landlord. But what you're talking about is, where do my patients go? Like, who actually services them? That can be a different or several different people. That's just a matter of making a referral. Does that kind of answer your question, Rachel?
Yes, also in terms of confidentiality, which Aaron brought up, which is part of my question, is there a negative in having a non-therapist that has been made aware of the confidentiality versus a therapist? I mean, legally, is it something like, okay, therapist by profession knows what this is all about, and therefore automatically confidentiality we're not worried about in terms of legality of it? Am I not making sense? I don't think I'm
It
making
makes sense.
sense.
Now, whether there's, but again, having a therapist where you do have that duty of confidentiality, that's certainly a lot safer and smarter. I mean, you could potentially have your attorney do it because there is an attorney-client privilege that can actually go past death. That can be helpful, but you likely want somebody with some kind of confidentiality if they're looking at those records. And the trite way of putting it, is it going to matter because you're dead, so nobody can really do much about it if a layperson sees it? Still not a good thing. One, they could potentially sue your estate for violating their confidentiality. So I wouldn't recommend it. It probably does make sense to have a therapist be the one looking through these other records and looking through clients.
Okay, thank you. So it's an ethical question more than a legal question, you're saying?
I'd say so, but it could open you up to your estate up to a legal issue if you get a client that's mad at some layperson going through your files and saying, "Oh, you have this and that problem," and I will now talk to another therapist. You're adding another person unnecessarily into the mix, if that makes sense.
Yes, thank you very much.
And yeah, I saw Nicole's answer, and then Ginger has that in there too. Yeah, for cashing the checks, that gets interesting too, and it depends. If you're incapacitated, it can actually, safest thing is we would do a power of attorney form for you, which is different from this, so that they can act as you. So again, there's another piece involved. So I didn't just dim out there. There we go. And yeah, you need a little bit more to do that. Now, will a bank or something accept this professional will to let them cash checks there? I'm not sure. Nobody's tested this professional will in Michigan at that extent. Again, this is really mainly a checklist tool to let a new replacement therapist know what's going on so that they can transfer your practice somewhere. So having a power of attorney if you're incapacitated makes sense. And then if you're deceased, you need either a personal representative or a trustee to handle all of that. And then they can step in and then coordinate with the continuity of care therapist about where the funds go and everything else. A lot of different pieces in this, is the best way to put it. Alrighty. If you run group practices, good idea to designate one of your independent contractors. Yep, certainly makes sense. Great to have an attorney handle it. Yeah, that would probably be a good thing too. Hope that. All right. Let's see. Another thing with the presentation. Let's go ahead and put here. All right. How many of you actually have multiple owners of your practice? Or are these mainly solo practices?
Solo, I think. I don't think that we have any. Do we have any part owners here?
Val and
Right.
Alex
Val and
are at
Alex.
My Body, but I don't think they're on right now.
All right, so this really doesn't apply to most people then. But if you do have a partnership or you have an LLC or a corporation with multiple owners, you want a buy-sell agreement so that you can have things transition. Again, since it's not too applicable to everybody in here, we're going to zip right through it. All right. Oh, all right.
I do have a question though on that subject. Can I ask a question on that subject?
Yeah,
I don't have a buy-sell agreement, but I do share an office space with someone else. So we share a lease agreement. And kept it fairly short the last couple of years. But anyway, if I die, is my partner responsible for covering my part of the rent?
It depends on what your lease says,
Right.
and the answer typically will be yes, unless you have two separate leases. If you guys have signed together a lease with a landlord that says the two of you will pay $500 a month or whatever else, landlord is most likely not going to say, okay, you can keep the same space and it's just $250 to you. They're going to look at what are the terms of that lease. So even if between the two of you, you have an agreement where the money comes from, it doesn't matter much to the landlord. Most likely that lease says, I don't care who it is, you're still going to owe for that space.
Right.
Yeah.
Okay.
Right. And the other piece is Liz asked about having independent contractors have a professional will. Can you talk to us about that? Certainly makes sense for an independent contractor to do that, but I guess it depends on the context. Again, if they're an independent contractor for your practice, most likely your practice should have policies about the patients in that practice, so that even if the independent contractor leaves, the clients are still cared for, and there's continuity under that overall practice. But an independent contractor may be doing things for multiple other people and may have their own private practice, and certainly having a professional will for them themselves makes a lot of sense. But if they're for your practice, it likely makes sense for you to have a document with them that says, okay, if you're working for my practice and you have this email that I'm giving to you as part of the practice, here's a newsflash for people. If the owner of a business gives you an email that's not your email, that actually belongs to the business, they have the right to see it and all the rest. So you need to make sure they have the password for it and everything else so they can get in if you as an independent contractor disappear. Yeah, independent contractors for your therapist, you have the same ethical duties to your clients. So you want to make sure that you do have the capability to have those clients looked after if you disappear from the practice or anything else happens. Hopefully that answers the question. That makes sense, or?
Yeah.
Okay, good. All righty. Perfect. All righty. The other thing is just a consideration for sole proprietors. If you're unincorporated or if you're in a partnership, typically when you die, your business dies with you. So it's a lot harder to sell the value of that practice. So depending on the situation, it may make sense for you to form a PLLC or a PCE, as it may depend. It also can give you some decent liability protection, do other nice tax things for you, depending. Just kind of worth looking into. Also makes it that it's easier to sell the practice later. So all of those are just things to consider. But again, it's not a must-do thing, but probably a good planning tool. All right, any questions so far on stuff? I'll also do is...
Aaron, can I ask a question?
Sure.
If you're working with someone on a professional will who's like a practice owner or sole proprietor, what are the tricky spots that wouldn't get covered? Like me filling out a template at my house and thinking that I'm amazing and a lawyer, which I'm not, versus actually you going through the process with them. What are the pros and the cons, if that makes sense? Like even your answer to Nicole Parker's question about having power of attorney for someone so that they can get access to bank accounts. What are the other things that we might not know are going to be problematic if we just do the template versus actually working with someone?
Really good question. And the answer is a template is a form that doesn't necessarily cover everything you're doing. So when you talk with an attorney, we can ask you questions as to how you do your business, and then how does it actually relate to what legally has to happen next. For example, where if you're going to have to go to a bank if somebody's incapacitated, having an actual legal power of attorney in addition to this therapy will would make a lot of sense. And a lot of it is that it'll be based on some question on, what is it that you're doing? What are you dealing with? And then we can kind of figure out how it applies. Some things in a professional will in that form may not make sense because you're not doing it. Or say, for example, you do have independent contractors for your practice. That needs to be addressed in the professional will and should be looked at. Or, for example, if you're an independent contractor and you have multiple points of contact with multiple places, all of that should be listed in your professional will. So there's a lot going on that depends on what your personal situation is. And I think Nicole was raising her hand there.
Yeah, sorry. Nothing changed when I hit the button, so I may have hit it a couple times. Sorry. I didn't mean to seem impatient. I was wondering about, you're saying that a legal power of attorney. So like if I'm incapacitated, help me understand. I've not had to do any of that. I'm not familiar with that concept besides the abstract. Like, because there's your personal power of attorney and then there's like the business power of attorney. Can you have it be separate so that like for my personal stuff, I would want my husband to be my power of attorney, right? But for the business stuff, does that then also mean, can I only have one, or can I separate that out? So like for cashing checks and banking kind of a thing, I can have my backup therapist person do that. Does my question make sense?
Yeah, it makes a lot of sense. That's a really good question. And the answer is yes, you can have two separate powers of attorney documents that are limited to whatever sphere you want them to be. And that will and those will work. I mean, you can say a power of attorney document that, say Fred or George has complete access to my business accounts, but Tom only has access to my personal accounts. That's fine. Again, you have to customize it. Be careful how you do it because you don't want to give the wrong person the wrong thing. Then depending on the document, you have to be kind of careful how you draft it as well. The other fun thing most people don't realize is that a power of attorney only lasts as long as you're alive. The minute you're dead, it's no longer effective. So then it will drop down to either your will or your trust. And there can be powers in there. Typically, when I'm doing one of these, it looks duplicative as all get out because you'll see these powers in multiple places because the answer is they are only effective under certain circumstances. So a power of attorney, good as long as you're breathing. As soon as you stop breathing, it's going to switch to your will or your trust and go from there. So you kind of have to do an integrated plan that meets all of your needs. I mean, you can definitely do separate powers of attorney for your business accounts versus your other accounts.
And then the follow-up question I had for that was like, if I was that backup therapist person for somebody else, and let's say that they don't really separate out, like if they don't have a business account, I would imagine, and I guess I know what my question specifically is, but like that would be kind of complicated. If they don't have it set up as a business LLC, PLLC, and they maybe don't have their business accounts separate.
Yeah, if some of your question got a little bit garbled there, but if I understand it correctly, you're saying that if you're not incorporated, you have business accounts that are personal accounts. That's not me, by the way. Well, we could have a musical interlude. That could be kind of nice. No. But if they are personal accounts acting as a business account, then yeah, that can lead to problems. You're going to have to. The workaround is you very specifically lay out exactly in the power of attorney exact accounts that they have authority over.
I think Nicole was asking actually the opposite. When she's a designated therapist for somebody else, she doesn't want to deal with their personal estate. But if I remember correctly, in the template that you showed us, there's a signature page where Nicole would accept responsibility for another therapist's practice. So I guess at that point, she will say to this therapist, I'm only doing your professional stuff. Do you actually have a plan for your personal stuff, because if you don't, I'm not signing this. I don't want to touch this. It's way too complicated.
Yeah, that would make sense.
Mhm.
But I guess in that side, you'd want to have the person making you the designated therapist, the backup therapist, to give you a power of attorney that just covers those business accounts and doesn't include the personal accounts, so that it only covers that aspect.
Yeah, that makes a lot.
And to make sure that they have a separate personal and business account from Go.
Right. And the scary part is they may not.
Well, that's what I was actually going to say. It sounds to me like whenever this template is complete, the best thing to do would be to take it to your actual attorney who has your family estate plan and make sure that it plays well with your estate plan, so that your attorney knows all of these pieces, who that person is, because there's so much interplay between the two that if you have one and you don't have the other, it's a mess.
Yeah, that it is. And attorneys tend to hate surprises. Surprise. Who knew? Yeah. Communication is important. What you have to realize is your attorney likely does not know how your practice works, doesn't know what your main concerns are, doesn't know how you do business. You need to tell them that so that they can put together some kind of a plan that works for you. And that's where attorneys are useful, because if you tell us what you're doing and what you want to have happen, we can then make it happen. If you just say, give me a standard estate plan, hope everything goes well, that's not as good as, then you can download a form and make some really cool mistakes with that, which we don't want you to do. Yeah, typically, again, if it's with your backup therapist, have an open line of communication, let them know what you are doing and what you would expect them to do. Let your attorney know what's going on and everything else. Hopefully that makes sense.
I think a couple of us are going to have sessions at 11, give or take, so we should be wrapping up. Are there final questions? And like I said before, the link to the recording and the template will be emailed to everybody, so you can have something as a starting point to your own plan. But any final thoughts or questions?
But thank you.
Yeah, you're very welcome.
Thank you. It was really interesting and useful.
Stuff.
Okay.
Thanks, Aaron.
Yeah, you're very welcome.
Thanks, Aaron.
All right, you guys take care and be safe out there.
Thank you.
Thank you. Stay healthy, everybody.
Driving through the
Bye, everyone.
snowstorm.
Natasha, do you want to stay on for a sec?
I can. I don't know if Aaron can keep us on for a sec.
Oh, sorry,
I
Aaron.
can.
That's
I
okay.
can just call you.
Yeah, call me.